Hey guys, so we have some new whistleblower documents. It's a FBI memo, an EC, electronic communication, which is used to open an investigation, and there's some emails attached to it. And what this has to do with is an FBI agent in the Washington field office back in June of 2019 was looking at an FEC complaint, the Federal Election Commission, a complaint on the Hillary Clinton campaign and Fusion GPS and Perkins Coie and the DNC, and how the Clinton campaign and Perkins Coie paid Fusion GPS for opposition research on Donald Trump, which then became the Steele Dossier, but they billed it as legal services. And in doing so, they concealed that Hillary Clinton's campaign had paid for the Steele Dossier, the same Steele Dossier that was then later presented to the FBI as coming from Christopher Steele, an MI5 agent and expert on Russia, and also a CHS for the FBI at a time, for one time. And I should say, I don't know how many years he was a CHS, but it arrived with some air of credibility, right? And reportedly was not connected to any political campaign. But it was literally paid for by Hillary Clinton, right? So this agent back in June of 2019, knowing those things, because it's become public by then, that this was actually Hillary Clinton paid for research, opposition research, and knowing that there was this FEC complaint from a watchdog group showing how the Hillary Clinton campaign had hid this payment to Fusion GPS or to Perkins Coie, and Perkins Coie had hid the payment to Fusion GPS for the opposition research. They had falsely reported it to the FEC. Later, they were fined for it. He wants to open an investigation. And what he does is he wants some input from prosecutors. So he contacts the DOJ Public Integrity Section, Richard Pilger, and he contacts J.P. Cooney of the U.S. Attorney's Office for D.C., who's the section chief for federal election, or the chief of federal election prosecutions or something like that. And then he also loops in, at some point, Anna Lou Tyrrell, who's over at the U.S. Treasury Department's Financial Crime Center, FinCEN. You may have heard of it. Not sure exactly how or to what extent she got involved in this, but she's looped in at one point, and I don't think that was on accident. So anyway, what he does is he sends in some emails. And he's just like, hey guys, I'm looking at doing this, opening up this investigation, and would like your input on what you think about it. I'm looking at this FEC complaint here, and we got some public reporting, and it looks like they were hiding these payments from scrutiny, and they broke federal election law. And I think we should open an investigation into this. What do you think? Well, they didn't get a response. I think it's 9 days go by. He gets no response. So he bumps it and says, hey, I haven't heard back from you guys. Just wanted to follow up, see if you had any thoughts on this. He also says, Rich, as in Richard Pilger, under a separate cover, I sent you a matter from a SAR that I am also seeking an informal consultation on. An SAR is suspicious activity report. Now, it doesn't say it's related to Hillary Clinton, Perkins Coie, Fusion GPS, but it also doesn't say that it's not. And it's not elaborated on any further in these documents, but I am very, very interested to know what that was. Maybe it's something completely different and it's not all that interesting. But him including it with this email about Hillary, the campaign, DNC, Perkins Coie, Fusion GPS, makes me think it very possibly is connected to one or more of them. And maybe that's how Anna Lou's involved. Anyway, the FBI agent, he got no response until June 14, 2019. 40 minutes after he bumps it, okay, says just following up with you, he gets a reply from Joseph Cooney over at the U.S. Attorney's Office. And the guy literally says I don't think this is a good candidate to open for a false reporting case. I think it would have been, I would think it would be exceedingly difficult to prove that this was a willfully false report. But he also says, I haven't looked at it. It's just that they labeled it legal services. And since Elias, when questioned about it, disclosed the existence of the Perkins Coie Fusion GPS contract, I just think it would be exceedingly difficult to prove that it was willful false reporting. So I don't think we should open it, or I don't think you should open it. And the FBI agent wants their input. These are the prosecutors who would be working a prosecution. And so he'd much rather open this investigation knowing that the prosecutors are going to carry it forward should he investigate the elements of the crime and actually put together a case for them, right? He then goes on to talk about a previous case of a similar nature and details what made it successful, about how this one entity, the campaign labeled it communications, but really it was a contract for media and videos from others, and it had to do with an endorsement, and it was payments for an endorsement is what it sounds like, although a lot of this is redacted. But he says, look, it's kind of similar, and you can see here, this is why I was able to take this case to trial and win, and the case you're proposing doesn't have those things, so I don't think it's going to work. He says, we just don't have, quote, we just don't have the type of direct concealment and purposeful use of a pass-through, which would be essential to carrying our high burden of willfulness, in court. So, June 18th, the FBI agent emails back, and he has a bit more to say on the matter. He says, look, I'm trying to better understand these three topics as they relate to the FECA, the Federal Election Commission Act, or something like that. In this matter, I'm trying to understand so I can work these cases smarter. All three topics have the same theme, which is what is the standard for opening an FECA investigation or not prosecuting an FC? This kind of tripped me up when I first read it. He said, all three topics have the same theme, which is what is the standard for opening an investigation, not prosecuting. And on my second time reading this document, that struck me, is that this FBI agent's pretty shrewd. He's playing dumb, though. He's playing, I'm trying to better understand. He's very shrewd, and he does understand. But he wants to know if he wants to know if prosecutors are actually going to take up a case should he substantiate it. And he's also doing something else, which I'll get to in a minute. But he wants to know what's the standard for opening the investigation in their eyes. And they're answering, what is the standard for prosecuting? That was what that first reply was about. It was about what it takes to prosecute it. He wasn't asking that. He's asking about opening. And he says, don't be confused, not to be confused with the standard for proving or prosecuting. I want to know the standard for opening an FEC investigation. From my experience with all violations, to find those compelling facts that are needed to prove the case in court for a prosecution, you have to do some investigating. I want to know why the Clinton campaign /Perkins/Fusion matter is not a good candidate to open an investigation. It seems that there's apparent, unambiguous concealment here. And that concealment appears to bring a new meaning thanks to reporting on these events, i.e. Fusion GPS, these past 3 years provides a viable path. It looks like it was a cutout. They paid their lawyer, Mark Elias and Perkins Coie, for quote-unquote legal services, and that's what they billed it. But then Perkins Coie went and hired Fusion GPS to do opposition research, and it was denied for years. Yes, Mark Elias, when questioned, disclosed this, but it's obvious this occurred after many people at the DNC and Hillary for America campaign either denied it or avoided answering that question. So it's not like he was forthcoming. And he asked more great questions. He quotes the CLC complaint, which is the watchdog group's complaint, and he says, is this accurate? Is what the complaint says accurate? If so, how can Fusion GPS work have anything to do with legal services? Stated another way, how is opposition research legal or compliance services, as that's what was billed or what was filled in on the Form 3 to the FEC, which, by the way, they later got caught and charged for by the FEC. Does the FEC approve of campaigns hiring law firms to then contract with third parties to provide any service? How do we know Perkins Coie was not purposeful pass-through here? Is there a difference between direct concealment and just concealment? Does the materiality of an ostensibly concealed disbursement affect prosecutor decisions on whether or not to open an investigation? He goes on to say, this is a complex violation, and so far what is opened and what is declined makes very little consistent sense to me. So the next day, Richard Pilger responds. In fact, he responds exactly 23 hours and 59 minutes later, almost as if he waited until it had been exactly 24 hours to respond. I don't know, maybe this is a coincidence, but I know it's something I noticed. He responds and says, look, JP Cooney over at DOJ, U.S. Attorney's Office for D.C., is correct in applying his discretion about the matter at hand for the specific reasons he spelled out. As JP explained, we don't have the stable regulatory base and unambiguous factual predication for your matter, for the thing you want to investigate. Taking a case off an administrative track at the FEC, which is where this complaint is, and into the criminal lane, which is where the FBI would take it if they opened this investigation, without unambiguously false and uncounseled reporting is a risky course. That's how he explains it. Says these expenditure cases tend to turn on magic words. In this context, the words of Form 3. It is facially a total lie, such as labeling something catering when it's something completely different. If that's what's going on, we can discuss further. But if it's mushy, like consulting or legal services, then I agree with JP, which it was here. It was a mushy word, legal services. Pilger then has some thoughts on the agent's metaphors and comments regarding Mark Elias. And he pushes back hard, and he shows in his reply that he's pissed off. He's a bit pissed off that this FBI agent is bringing this stuff up. He then lets the agent know that no consult with the public integrity section is required of you when you take a matter to DC or EDVA, which is why I left it to JP previously. And he belittles the agent. Well, the FBI agent responds 3 days later, plucky as ever. He thanks him for the response. And he says, so can I share some others that others are interested in the FECA case predication? I believe your salient points in the plainer language are, and he restates what Pilger just said to him. But he states it in a way that is pretty humorous. He goes at him. It says, if I'm understanding you right, the facts prior to opening were compelling, and most of the facts JP mentioned were known at the opening of that other case you brought up. And then he lets them know he studied it. He says, yeah, it's a good case to study in Sentinel. So yeah, I looked at it. I know what it is. 2, since the alleged concealment was by or through a law firm, the advice of counsel hurdle cannot be overcome. So we shouldn't try. A disbursement to a law firm labeled as legal services consulting when it was really a non-law firm vendor for opposition research by a foreign national is too mushy. It's too ambiguous. So it's unappealing to open and a hurdle that likely cannot be overcome. So we shouldn't try. Thanks for the guidance on the Form 3s. I know the FEC site well and will look into the Form 3s and get back to you. While FEC policy on disbursement reporting, as stated in the CLC complaint and pasted in my email below, seems pretty clear and unambiguous to someone like me, in truth, it's not clear and it's very ambiguous. 5. By opening on this matter, since there was likely advice of counsel and the words are mushy, we would risk a bunch of bad legal stuff happening with the FEC. And as you describe it, that bad legal stuff seems pretty dire. I've been told the FEC basically does nothing about these, so we are really taking this off an administrative track. Thanks. Just as snarky as ever. And it pissed Pilger off. He says, redacted, the matter is not well predicated, and yes, I meant what I said about the FEC. This continued back and forth isn't what we do with line agents, and you are unique in doing it. In fact, we have written policy against it. At best, we are creating potential discovery on internal policy and deliberations. At worst, you are creating jinx on yourself, meaning discoverable material that in a future case could get turned over and make them look bad. We might have to turn over in the matters to cross you for bias or rush to judgment. If you remain dissatisfied, please have your ASAC call Anna Lou over at Treasury. He is not happy. So the FBI agent emails his superior, it appears. And then in his reply back to his superior, he goes on about how he's belittling me. I've been an agent for X number of years. I'm very successful. And I was seeking their guidance, their input. And this is totally out of line because what he's doing is it would have a chilling effect. If some other guy who's new, a new FBI agent came in, sought Pilger's advice on opening an investigation, just asking genuine questions in good faith, and got that kind of response, it would have a chilling effect on that FBI agent, and it would risk that FBI agent not pursuing good leads in opening cases. It's bad. So, but then he does something that I think I just love. And maybe I'm reading too much into it. But July 9th, 2019. So a couple weeks after this chain of emails, right? He decides to take out an FBI electronic communication. And he decides to document that he consulted for a prosecutorial consultation supporting the opening of an FBI investigation into the DNC violation of campaign finance law for falsely reporting the disbursements to Fusion GPS as something other than opposition research. Meaning he decided to document that he consulted with the U.S. Attorney's Office Section Chief for Election Crimes, Cooney, and he consulted with DOJ's Public Integrity Section, Richard Pilger, for their input on opening an investigation into the DNC paying for the Steele Dossier and then concealing that payment as legal services. And he writes this opening EC. He includes some public reporting on it. He includes the Form 3s that were on the FEC records. He includes the complaint from the watchdog. And he includes how now that we know what was really going on, this whole concealment of these payments takes on a completely different meaning than them just saying, oh, well, it was legal services from Perkins Coie. So he puts that all in there. He then quotes the input, some of the input he got, but he includes all those emails here. And so in doing that, instead of turning away and letting these be just some scuffle, right? An email scuffle. Instead of doing that, he turned it into an official document in FBI records. He documented that he got shut down on trying to open up a case into the Steele Dossier and the DNC paying for it. And he filed all that correspondence on record, and now it's public, which I think is pretty great. I think it's really great. And if you want to know, you want to see more of this, I'll link my thread in this description of this video, which also includes the description, a link to the documents. And on my my next episode, it'll probably be on my Just Human podcast, episode 354. I go into these documents in more detail. So if you're interested, Make sure to check that out after I publish it. All right. See you on the next one.